the court has 40 cases on its docket. It's generally been deciding about 60 or 65. Two areas which the court might get into, which could dramatically change what this term will look like. One involves voting rights and whether or not the pre-clearance provisions in the Voting Rights Act, which require states with a history of racial discrimination in voting to get the approval of the Justice Department or a court here in Washington. The justices, some of the justices, Justice Roberts for one, a little skeptical of that. If they have a chance, they may take that up and that provision may be gone. We don't know. Then there's the Defense of Marriage Act. The Court of Appeals Federal Court of Appeals in Boston struck down Section 3 of that act as an unwarranted federal interference in a domestic institution. Same-sex couples who are married in Massachusetts, for example, can't file joint tax returns. Just the week before the term opened, the Second Circuit Court of Appeals in New York heard arguments on the constitutionality of the Defense of Marriage Act. And there's a thought that while the court didn't take the Boston case now, it may just be waiting for a few more cases to get there. Justice Ginsburg said that this is going to be on the docket before the term ends. So keep tuned. Things could change as far as what this landscape looks like. This is a case of Fisher versus the University of Texas. Abigail Fisher is a high school graduate in Texas who did not get admitted to the University of Texas, much to her regret, and sued, claiming that the university's policies for admission pay too much attention to race. Both its so-called 10% plan, which admits students in the top part of their class regardless of what high school it is, so minority high schools are going to have minority students there. And then a second part of the plan, which admits the 25% or so who don't get admitted that way, which is not based on race. It considers grades, extracurricular activities, but it also does give some attention to race. And the university says it's based on a University of Michigan plan, which the court upheld in 2003, 5-4. And what Abigail Fisher has said is the university already takes race into account through its top 10% plan. That this plan, this second phase of the admission policy, is inconsistent with the Michigan plan that was upheld by the court. And if the court thinks it is consistent, well, then it ought to throw out the 2003 decision because it's a violation of equal protection. The 4 dissenters in the Michigan case in 2003, 3 are still on the court. And the 4th was Justice Rehnquist. He's replaced by Justice Roberts. I don't think anybody thinks Justice Roberts is going to side with the University of Texas. Of the 5 justices in the majority, though, especially Justice O'Connor, who wrote the opinion in 2003, she's replaced by Justice Alito, who's quite skeptical of affirmative action. So there you probably have 5 votes already, at least to strike down the Texas plan. We can speculate. Justice Ginsburg and Breyer are still on the court, but as I say, O'Connor is not, replaced by Alito. Stevens and Souter have left, replaced by Kagan and Sotomayor. And they're probably more reliable votes for the University of Texas, but Kagan's not participating. She was Solicitor General guiding this litigation in the lower courts. So I think most people think the Texas plan may be gone. Whether or not the affirmative action decision of 2003 gets overruled, that's a closer question, and a lot of these things, it comes down probably to what Justice Kennedy thinks. The first 2 cases on the term, in a sense, illustrate the range of things the court deals with. One involves the Alien Tort Statute. This is a 1789 statute, which for most of the country's existence has been dormant. Basically, it says foreign nationals can sue in federal court, in U.S. courts, alleging violations of international treaties or international law or U.S. treaties, to which they have suffered, damages, incurred damages. And the question here involves some Nigerian individuals who want to sue oil companies based on charges that the oil companies helped the Nigerian government deprive them of their rights when they were protesting oil drilling in Nigeria. The question for the court is whether or not this Alien Tort Statute extends jurisdiction to activity that took place entirely in the land of a sovereign nation. And some nations aren't real keen about this because they regard this as unjustified interference in their domestic affairs. And some people say if the Congress wants that statute to be read that way, it ought to say so, and it hasn't said so far. But then the other case involves something called a floating residential structure. A guy has a barge which is unable to move by itself and has no steering apparatus, and he lives on it. And in a marina in a city in Florida, he lived on a marina in Riviera Beach, Florida. And the city sued him because he wasn't paying the fees for the marina. And they sued him in federal court because they said, this thing is a vessel, and that's a term of art. And he said, no, it's not a vessel, and I should be in state court. Now, you ask yourself, why would the Supreme Court of the United States care about that? Well, the reason is, if this thing is a vessel and federal jurisdiction extends to it, it extends to a lot of other things that are similarly situated, like casino riverboat gambling organizations or outfits. And it asks the question whether or not laws protecting seamen will attach to individuals who are working on these barges. So what appears to be a kind of a funny little local conflict really has big implications for the workload of the federal government and the federal courts.